Hello everyone, my name is Cletus and welcome to the Cleanse. So without further ado, let's get into this video. But before we get into the video, guys, I want to say thank you so much for smashing the like button in the previous video. Let's continue to do so because, guys, this action, it brings us more honorable members of the clan. And if you are new to this family, you are warmly welcome. So I don't want to waste too much time because I got somewhere to go and I have a lot to do this evening. So let's go to the Gauteng High Court in Judge Rata's courtroom. What in the court's waste of time are we experiencing these days? It looks like since this case has resumed, this is the Senzo Mewa murder trial resumed, it's been nothing but a waste of court's time. Okay, I understand the legal aid board situation because I kind of am on Rata's side with this one. Yes, Mr. Mangena did take to the stand as a ballistic expert regarding the gun that is owned or was owned by accused number 3, I think. And of course, the defense was like, no, we're going to get our own ballistic expert who is going to speak to this evidence, whether to rebut it or to agree with whatever Mangena had already testified. And therefore, he was stood down until Mr. de Klerk, who was at the time was in Uganda training the Ugandan police. He kind of like said, please give me some time. I think he gave them up until September or so, but he was still going to be busy throughout 2023. Okay, I get that. But the other thing that I feel like Rata should be a little bit empathetic about, not empathic, that he should be understanding about is the fact that we did go through a trial within a trial for how many months? Almost 5 months or something like that. So he must not necessarily blame the defense on this, because they need to focus on defending their clients so that their clients cannot be prejudiced in any way, whether the defense lawyers are under pressure to get Mr. de Klerk and things of that. They just needed to focus on the trial within a trial. So I felt that there he was being very unfair a little bit, but at the same time, this is Rata when it comes to the defense. He just doesn't like them, period. Even the way he was listening to this lady, whom I'm not going to mention her name because I do not want to butcher people's names. All I'm going to do or refer her as legal aid board. The legal aid board lady, basically, she was there because somebody was snitching. And then Rata is like, yeah, you see, on the 5th of April. And I'm like, but you remember, sir, there was a trial within a trial. After a trial within a trial, after so many months, then you went to recess where these people were going to get de Klerk from. Yes, they did get de Klerk, and then they asked de Klerk to do some couple of things. And then only on the 5th of April, they were able to go to legal aid board and say, listen, can you pay half of what we already paid to Mr. de Klerk so that we can proceed with the ballistic expert's testimony? But of course, as Mr. Rata Mokgotleng did order for the legal aid board to come to court today and give or at least shed some light as to what is happening with this application so that the defense can call its expert witness and then rebut Mr. Mangena. And then, of course, this lady came. I think she is a head of office in the legal aid board, but at a regional level. I liked how she explained everything. Fine, I accept that an application was made on the 5th of April. Again, I would say it's because of all these activities that took place since the end of the trial within a trial. And then, of course, she says that if the funding is less than 50,000 Rand, of course, she's going to approve it because that is her responsibility. However, if the funding is above 50,000, so that means 50,000 going to about 300,000 or 350,000 Rand, then it's a provincial that is going to take that decision to fund the defense. If it's above 350,000 Rand, then it goes to national. I think she spoke about something about constitutional, whatnot, not. I'm just going to say it's a national office that's going to make the decision whether it's going to fund this ballistic expert in de Klerk. But we will see, because apparently, according to this, the legal aid board, she says that costing was not attached to the application, to Rata's shock. As if Rata doesn't know that it's actually the expert that does the costing, breaking down his own costs. Of course, the only thing that the defense could do at this point is to make an application, say, hey, we intend to make an application to have our clients being funded so that the ballistic expert can come and testify on behalf of their client. But of course, at the same time, they would also ask or instruct Mr. de Klerk to please break down his costs so that he can submit it to the legal aid board. And apparently, he cannot speak to the legal aid board directly, but instead he needs to speak to the defense, whom in the name of Mr. Sibia. And Mr. Sibia told the court that yes, he's done most of the work. The only thing that he's waiting for is for the ballistic expert to break down his cost. And therefore, he submits to the legal aid board to make a decision whether it is well within the means of the regional legal aid board, which is the lady that came to court, or it's going to be escalated to provincial if it's any more than 50,000 rand and about 200 or 300,000 or something like that. And if it's more than that, then of course going to be escalated to national. And they talked about it, the period of time this might take between 2 days and whatever not. Then Rata Mokgotleng, after listening to all the submissions that were made by both the legal aid board and Mr. Mnisi, then he decided that, okay, he's going to stand down Mr. Mangena's testimony as a ballistic expert for a month. And then he wanted to know from the defense if they agree with this postponement. Of course, Mr. Mnisi said it's going to take less than a month for everything to be put together. But anyways, he does not have a problem with that being done. Mr. Mangena, therefore, his testimony was once again stood down for another month. They all agreed that on the 20th of May, 2024, Mr. Mangena, as well as Mr. de Klerk, will take the stand, and basically they are going to go head to head about this particular gun that is said to be that of Mr. What's his name again? I forget his name. Accused number 3. Let's just put it that way. Accused number 3's gun. We already know that that gun, by the way, is the accused number 3 is already convicted for it. And therefore, to me, it sounds like double jeopardy that we are dealing with in this particular segment of this trial. But anyways, we are going to hear what exactly the outcomes of this particular gun. Does it belong to accused number 3 or it does not belong to accused number 3? I understand the preliminary reports have been organized by both Mangena as well as Mr. de Klerk. So it's a matter of now taking the stand and arguing it out, and then we get to hear what's what in the what, right? Then after the whole legal aid matter was done, which I still call it a little bit of a circus, well, because Rata, you know, he's just so over-exaggerative when it comes to some of the things. And I feel like, come on, bro. Everybody just came back from trial within a trial. Just give them people some grace to put their cards in order. It's not that they were just discarding this Mr. Mangena issue. They were always having it in the back of their heads. But anyways, Mr. Baloyi then did something that we are already accustomed to when it comes to Mr. Baloyi ambushing. At this point, I think we should call him Mr. Ambush, because he came with a witness who came to the stand and said, oh, well, I am here to testify on Mr. Steyn, a retired police officer, or what do you call this, cell phone ballistic examiner. And I was like, wait a minute, you are coming to testify on somebody else's statement? Wouldn't that be hearsay? But anyways, I was very interested. I had my ears wide open. I was like, okay, let's hear how this one is going to play out. And exactly how it was playing out in my mind, it did. Because the defense stood up and objected to this and said, no, you cannot have somebody that is going to testify on a statement that does not belong to them, even though their name has been altered. It was Steyn's name who swore under oath that he's going to tell the truth and nothing but the truth on that particular statement. And they just removed his name and they put this guy's name, Mr. Gideon Gous, I think. And I was like, okay, that's interesting. But that is so Baloyi. It was so Baloyi through and through. And then I was like, okay, if I'm the defense, definitely I am going to object to this. And indeed, the defense did object. And they put their points quite clear that it will be prejudicial to their client if this particular individual take to the stand on somebody else's statement. Therefore, this statement ought to be amended to Judge Rata's agreement. Rata said yes. This statement needs to be amended. There is no way that you are going to have a witness on the stand and as you go, you amend the statement. Is that even legal? That was my question. So Judge Rata decided that, you know what? Let's just postpone this matter until tomorrow to give the state time to amend this statement so that when the witness comes to the stand, he owns that statement. Therefore, he would not say, well, it was not me, it's Mr. Steyn who did that, and therefore Mr. Steyn must come and answer for himself. You know how they do it when they try to deflate away when they need to take accountability? So that is what Mr. Mgomezulu was saying, that I am not going to be cross-examining somebody on somebody else's statement where there's a part in the statement is a hearsay and I have to tell the witness that this is hearsay. But for me, it was more like when Mr. Steyn has to answer the real question, the hard ones, and then you'll be like, well, I was not there. That was Mr. Steyn. Then you have to call Mr. Steyn. That stuff, that whole thing, it looked like that. That was the plan, that we're going to call Mr. Gous, who is going to speak on this statement. But when he's asked tough questions, he's going to refer, just like what's happening with Mabena. When Mukhane takes a stand, oh, well, Mr. Mabena, I can't wake him up. Well, may he rest in peace. The Mabena excuse. Now it was going to be the Steyn excuse. No way. So I was very happy to see when it was postponed until tomorrow. Yes, the Senzo Mewa murder trial is postponed until the 17th of April 2024, which is tomorrow morning at 10 o'clock. And we are definitely going to still be following it. And I'll bring it to your attention. I know a lot of people have fallen away from this case because they are annoyed by the judge. And also fatigued as well by this case because it's just going on and on and on. We want to deal with the AKA story now. It's getting more hotter. It's getting hotter, people. The AKA story is getting hotter. And I cannot bring it to you until the Senzo Mewa murder trial is over because you guys don't watch. If I bring the AKA matter and be right before you, y'all just look away. Y'all look away. So if it's over and then we have the AKA story on its own, maybe this is when I will get your attention, just like I got your attention with the Senzo Mewa murder trial, right? Let's be fair that way. So now it looks like Rata is just taking way too long. There was a point where I thought Rata was just going to say, you know what? This is it. I am throwing this matter off the roll or striking it off the roll or throwing it out of court. But, well, it was not to be. Anyways, guys, please do watch some clips that I edited for you so that you can check out what transpired in court today and get yourself some little shock therapy with the particular witness that Baloy was bringing on the stand. On my side, guys, I will see you next time with a new video. Please, whatever you do, smash the like button and make sure that you subscribe if you have not subscribed yet because I've got a lot to talk about when it comes to this matter. See you. Bye.
Fabio Isola. Yes. You are from the Legal Aid Board?
I am.
Which position do you?
I'm the head of office.
The?
Head of office.
Head of office. I want to commence a preliminary inquiry in terms of Section 342A of the Criminal Procedure Act. When there is a susceptible delay in the proceedings, what predicates that delay? I just want to find out. And it's an informal thing. You don't even have to swear to tell the truth. It's just, if you read Section 342A, they say it's an informal inquiry. Just to find out what happens. I will tell you, there's a witness called Mangani. What's his first name, the gentleman?
It's Colonel Mangena.
Yeah, sorry, yeah. Colonel Mangena. He's a ballistic expert. He gave evidence in this trial in August last year. When the cross-examination had to commence, the defense requested that it must be adjourned until they have consulted their own expert. And thereafter, obviously, that expert will also prepare a report, whatever. And then they will be able to take the matter up by cross-examining this gentleman who gave evidence for the state. Now it's 8 months. That has not happened. By any standards, when you read Section 342A, if there is a delay which prejudices the state, the defense, even the witnesses, even the public in the interest of justice, they say it's incumbent upon the presiding judge to investigate the exigencies which are currently making it difficult for this case to proceed. Now, I thought, because the accused have enlisted the services of the legal aid, ordinarily you would infer that they don't have the money to pay for a ballistic expert. And they subsequently advised me that they applied to the legal aid to bridge the deficiency which is short in terms of the payment or the cost which is demanded by the ballistic expert. Now, all I want to know is that correct, that an application has been made to the legal aid board to fund the ballistic expert report and the cost of the ballistic expert giving evidence in this court?
That is correct, my lord. They did apply
When did they apply, ma'am?
on the 5th of April
This year.
this year, yeah.
That's the problem.
2 weeks ago.
Yeah, you see, that's the problem because, as I say, in August, this is what they told me they're going to do. Now, you say they applied on the 5th of April.
That's correct. In terms of our approval framework, different levels of approval obviously is made.
Okay.
So if it's, for example, under 50,000, I can approve it at the local office. If it's between 50 and 350,000, it must go to provincial office. And if it's above 350, it goes to the CCMC, which is the Constitutional Case Management Committee. So it really just, and that's why we need a value of the cost. That
Was the, sorry, just to chat it, was the value not finished?
not yet.
Okay, fine, thanks.
My lord, it's true that the legal aid board has not yet been finished with the information that they would need for the purposes of costing. However, I don't do that myself. I'm also relying on the expert. I've been in communication with the expert, but I've got reasons to believe that he could be engaged somewhere else.
I mean, cell phone.
But my lord, it is not really entirely accurate that I can't communicate with him,
What
because
is-
that is what we have actually been doing. Unfortunately, we don't know what is it that is delaying him, because the delay as of now, it is on his part. But we have just confirmed yesterday that we need that information as soon as possible. And in fact, I had requested in the email that I've dropped him that he should liaise directly with the Legal Aid Board South Africa. He should directly send that information to Legal Aid Board South Africa. But now Legal Aid Board says, no, they don't work like that.
Yeah.
He must do things through me. That's information that I did not have. And then I requested him yesterday, after I received that information from Legal Aid Board South Africa, that he needs to direct that quotation to me, and then I forward it to Legal Aid Board South Africa. He's busy working on it now, my lord. It is not as if we have not done anything.
So how long should we postpone for the evidence of Manganye to be cross-examined? How long? I don't know. You should know.
Probably, my lord, I think it will be a prudent thing if we meet.
Yeah, how long?
One
time frames.
If there's from where I'm standing, say almost a week or two.
I'll give you a month. How's that?
That will be fine, my lord, but that is going to happen even before that,
Yeah, we'll see.
as it is the court, my lord.
Ma'am, is it okay a month? I know you're not supposed to liaise with them. It's not, that is a procedure.
Yeah. No, my lord, it depends on how much the quote comes, whether it's done in my office or provincial office. If it has to go to CCMC, it is a bit longer, the constitutional case, but I will, we have discussed it already, because this issue was raised by we discussed it at our national office. I will send the request, if it has to go up to national office, via round robin, but that'll take a couple, more than 2 days to finalize. And then obviously, I'm not too sure how long the expert will take to finalize his report and be ready. That's obviously, it has to do with...
I thought he had started on the report, Mr. Mnisi. Has he started on the report?
Yes, my lord, as I've said, we've got a preliminary report. It's not like it's going to start afresh.
Okay, then it's agreed then that the matter regarding the cross-examination of Mr. Mangena will be postponed to the 20th of May for such an exigence. Is that okay? Thanks ever so much for your assistance.
It's a pleasure, ma'am. Please be excused.
Thanks. Your excuse.
The witness is going to testify in respect of 2 new exhibits. We've marked his affidavit, exhibit DD in brackets 5, and that affidavit is accompanied by annexures. Annexures, it's several annexures. We've marked those annexures. Exhibit DD5 is annexure 1 up to annexure 17.
It's DD5, 1, 2,
Yes.
3, 4, 5.
Yes, no, it's just all of them, just annexure DD51.
Oh, I see.
Yeah.
Okay.
We didn't number the page, my lord, of the annexures. The witness is going to make use of
The
monitor.
wat ek taal kies E, Afrikaans of Netherlands?
English, my lord.
English. Okay. Can you swear the witness in then?
Sir, do you have your full names and surname, please?
Gideon Gous?
Do you have any objection in taking the prescribed oath?
No.
Do you swear that the evidence you shall give shall be the truth, the whole truth, nothing else but the truth? If you do swear, please raise your right hand and say, so help me God.
So help me God.
Witness on in
Thank you.
Right. Lieutenant Colonel Gous, just before we get your affidavit, can you just explain how you come into the picture at this point of the proceedings?
I was analyst at the PCMC in Gauteng for quite a few years. And then after Colonel Steyn was retired, he had to retire on 60. He had to leave the force. Brigadier Kaninda contacted me and he asked me to help him with some analysis of cell phones.
Is it correct that you have prepared an affidavit in terms of section 213 in brackets 1 and 2 of the Criminal Procedure Act, and your affidavit is accompanied by annexures 1 up to 17?
That's correct, yes. On 2023-09, I was contacted, I said Colonel Steyn, I was contacted by Brigadier Kaninda from the cold case, and he directed me to assist Colonel Steyn on the analysis of a downloaded phone on Vosloorus 636 of 10/2014. On 2023-09-06, I received a request form and a CD marked Vosloorus 636-11-2014.
Sorry. As you know, Mr. Gous differs from the content of paragraph 5. He has explained that Steyn is retired and that Kaninda went to consult him to take over the process. Are you going to apply for an amendment? Because this is an affidavit. If it goes any other place, there'll be some smart aleck who will go to the constitutional and say, oh, you know what, court, this affidavit calls about Steyn. And also Servetter is not here. He's no longer there, he's retired, blah, blah. So what's your view, sir?
Indeed, as the court pleases, the state will request that the amendments be effected as the witness has testified. There are other places where there will be amendments as well. We request that his evidence be regarded as having amended the affidavit.
What about the defense? Any objections, Mr. Gomezolo?
No objection.
Mr. Msipiri?
My Lord, my point is different.
Your what?
The affidavit should be read as is, and he'll be led on the amendments by my learned colleague, my Lord, because this is an affidavit.
Nisi?
As it is the court, my lord. In terms of procedure, you do not amend an affidavit.
I know.
Provide a supplementary affidavit.
Yeah, I know. That's why I was saying smart alert will go to the constitutional court and say Steyn is dead. But he can apply for the amendment and he knows how to do it subsequently. Okay?
An affidavit, my lord, can only be...
I've heard you, Mr. Minister. So you want us to adjourn?
No,
Then, no, just listen to me.
I'm saying,
So we can adjourn, and then you bring about the... Wait, and you bring about the amendment. As Mr. Ramaphosa says, we must adjourn then. Yes, ma'am.
My lord, my case is different
Mm-hmm.
because our clients are suffering prejudice as the amendments are being effected on the witness box. We have not been furnished with the supplementary affidavit, and we do not know what the information that will be supplemented. We are taken by surprise as the witness wishes to explain and amend the paragraph as he likes. We're not aware of what is going to be supplemented, my lord.
Okay. Is anything going to be supplemented except the fact that Steyn is no longer the person who did the analysis?
Well, really nothing major.
What?
No main amendments to the affidavit, my lord. I think there will be one more minor amendment, but nothing major. It doesn't go to the, and I'm surprised Advocate Mshololo says there are prejudice. How can one name being substituted by another name cause
Then it's a prejudice.
But in any case, my lord, nothing major. We suggest that we go along, and in the interest of time, that the evidence is put in record.
Mr. Ngomezu.
My submission, my lord, independently so,
Yeah.
is that this is an affidavit.
Yes.
Any discrepancies that are placed on record on the contents of this affidavit can be challenged to this witness.
Yes.
Irrespective of the procedure to file a supplementary affidavit. This is just a mere amendment. The issue that my advocate Mshololo has raised is whether is it prejudicial to the accused persons. Anything material that is prejudicial, there's a reason to object.
Of course.
To amend.
Of course.
But in the circumstances, if I find hearsay evidence, say for instance, I'm cross-examining this witness, it comes to my attention that paragraph 5 is hearsay.
Yes.
Then I have to put to this witness that this paragraph constitutes hearsay and the court cannot accept this evidence. That's how it should be done. That's my submission.
Otherwise, I don't have a problem. Let's adjourn. Come back tomorrow. Maybe understanding goes with experience also. Just draw a supplementary affidavit. You did contact him, but he's no longer available because he has retired.
I was contacted by Brigadier Kaninda to take over the case because Steyn is going to retire.
That's it. So just put on the supplementary affidavit. We'll adjourn until tomorrow. Yeah, let's adjourn until tomorrow. Just bring that. I'm sorry about this.
Well, the other thing, my lord, will perhaps file an amended affidavit to all our colleagues.
Yeah, do that. It's a waste of time, I can tell you.